mental health law. You know, on the surface, it sounds like it should be pretty straightforward, right? A set of rules to help people.
Mm.
But when you actually start digging into it, it gets really tangled. You've got individual rights, ethical stuff, and this constant balancing act between someone's freedom and what they might genuinely need.
Absolutely. It's a real tightrope walk.
So today, we're diving deep into this collection of writings, rethinking rights-based mental health laws. And it does exactly that, takes these complexities apart from, well, all sorts of angles.
Yeah, and this isn't just, dry theory. The chapters in here, they tackle really current, real-world problems that crop up precisely because we built these laws around individual rights.
Okay.
So our goal today, I suppose, is to really get to the heart of those tensions. How do we protect what people are entitled to, but also make sure the system actually, works, provides care?
And this collection is structured really well, I thought. It breaks things down into 6 main parts.
Mm-hmm.
We'll be looking at the history, which is actually pretty surprising. Yeah, it is.
The international human rights stuff that's shaping things now, like the CRPD. Then the gaps. And sometimes there are huge gaps between the law and what happens in practice.
Which is crucial.
Absolutely. And then review processes, tribunals, and finally the big one, access to services. Can people actually get the help they need?
And, a really central theme that keeps coming up is how our whole idea of rights is shifting.
Right, the negative versus positive rights thing.
Exactly. Moving beyond just negative rights, protecting people from interference towards positive rights. So the state actually having a duty to actively support people, help them participate in society.
So the ultimate aim of the writers here is to push for laws around treatment, detention, care. Laws that are workable, but also really line up with international human rights documents.
That's the core idea, yeah. Making it real and rights respecting. And just to give you a sense of the expertise involved, the contributors are, well, heavy hitters in the field. We've got Annegret Kempf, Oliver Lewis, Bernadette McSherry, Tina Minkowitz, Jill Pei, John Petrilla, people from Monash, LSE, advocacy centers. It's a really diverse and knowledgeable group.
Definitely adds weight.
Okay, so with all that set up,
Yeah.
where do we even begin to untangle this?
Well, I think understanding the history is a really good starting point. The collection has a section on historical foundations, and it really shows how far we've come, or perhaps how much the focus has changed.
It really does. I mean, it's kind of wild to learn that early English mental health laws, back in the 13th century, were mostly about protecting property.
Yeah. Property of people deemed of unsound mind. The king acted as parens patriae, like a sort of guardian.
Right, managing their lands, which, also happened to benefit the crown's finances.
Convenient, that.
It's just a million miles away from how we think about autonomy and rights today.
Totally. And from that property focus, you see this slow, gradual shift towards thinking about, well, beneficence, doing good for the person, but also protecting the community and eventually individual liberty.
You can see that juggling act even now, can't you? Like in current Australian laws,
Yeah.
trying to balance all those things.
Exactly. The whole basis shifted from protecting estates to protecting, or at least managing, the person.
Yeah.
And that shift is still causing debate.
And this evolution continued, right? The collection mentions major reforms in England and Wales, the Mental Capacity Act 2005, the Mental Health Act 2007. Sounds like they were pretty significant.
Oh, definitely. They essentially formalized the power to detain and treat, broadened who could use that power, and even set up ways for non-consensual treatment out in the community.
Right.
Which leads us nicely into this concept the collection discusses, rights-based legalism.
Okay, rights-based legalism. Let's break that down. What does it mean in this context?
It basically means prioritizing mental health laws that explicitly mention and protect the rights of individuals with mental illness.
So the rights are front and center in the law itself.
Precisely. The collection uses Section 4 of the old Victorian Mental Health Act as an example. It stated very clearly that protecting rights and minimizing restrictions on liberty, dignity, privacy, that was a key objective.
Makes sense.
Yeah.
So why this move? What was driving it?
Two main things, according to the collection. One was wanting to limit the very wide power doctors traditionally had.
Right, the medical discretion.
Yeah. And the second was a push to dismantle the old asylum system, which was, increasingly seen as ineffective and often harmful.
Okay, so reining in medical power and moving away from institutionalization.
That's the gist of it.
And this connects back to that negative versus positive rights idea again, doesn't it?
It does. Rights-based legalism initially really focused on those negative rights, freedom from arbitrary detention, from bad treatment, from violations of dignity.
Protecting people from harm.
Yes. But the conversation, as we said, has moved on to also include positive rights, the state needing to actively uphold dignity, protect from abuse, ensure access to community support and services.
Which brings us very naturally to the international human rights side of things. The European Convention, and especially the UN Convention on the Rights of Persons with Disabilities, the CRPD.
The ECHR has definitely been important. Article 5(1)(e), for instance, has been used quite a bit by individuals to challenge compulsory measures, setting limits.
But the CRPD, the collection argues that's been a real paradigm shift, hasn't it?
Oh, hugely. The CRPD basically reframes mental health issues as disability rights issues. Its fundamental message is that having a mental illness or a psychosocial disability, as the CRPD terms it.
And that term itself is significant psychosocial disability, not intellectual disability necessarily.
Right, specifically referring to users and survivors of psychiatry. The point is that disability alone can never be the reason to take away someone's fundamental rights. That's a massive departure from older models.
So it emphasizes positive rights.
Yes, dignity, non-discrimination, social inclusion, living independently, education, work, all the same rights as anyone else with a disability. And crucially, it rejects the idea that having a disability justifies depriving someone of their liberty.
That's a powerful stance against detention based purely on diagnosis. What about specific articles? The collection mentions 16 and 14.
Article 16 is about freedom from exploitation, violence, and abuse, hugely important in mental health settings, unfortunately. And Article 14 reinforces that right to liberty and security, stating disability can't be the sole grounds for taking freedom away.
The CRPD also seems big on capacity to act.
Yeah.
It's not just about diagnosis, but can the person actually make a decision?
Exactly. It pushes away from automatically assuming incapacity based on a diagnosis. The focus shifts to, can this person understand information, weigh options, make a choice, communicate it? It's about functional capacity.
And this links to the idea of legal counsel, too.
Yes. MI Principle 1.3 highlights that right to independent legal counsel, someone separate from the facility or family when capacity is being assessed.
And a huge part of this CRPD approach is supported decision-making.
Absolutely central. Instead of substituted decision-making where someone else decides for you.
Like a guardian making all the calls.
Right. Supported decision-making is about giving the person the help they need to make their own choice. That could be accessible information, respecting their way of communicating, maybe using advanced directives they made earlier.
The collection mentions the Personal Ombudsman program in Sweden.
Yeah, in Skåne. It's given as a real-world example of a user-controlled support service, helping people navigate systems and make their own decisions. Really interesting model.
It sounds very empowering.
Yeah.
But the collection is also very clear about the gaps between law and practice.
Yeah.
This is where the ideals meet reality, often quite harshly.
Precisely. Having rights-based laws is vital, but implementing them throws up all sorts of practical problems. Like just the basic question, why single out mental disorder for special legal treatment at all? That's still debated.
And even key legal terms can be fuzzy in practice, like objection to treatment. How do you actually measure or define that consistently?
It's really difficult. The collection mentions research, studies on psychiatric inpatients showing how hard it is to pin down what counts as a valid objection. Depending on how you define it, you get very different numbers of people seen as objecting, which directly impacts whether treatment can be forced.
And that line between having a disorder and lacking capacity,
Yeah.
it's not always clear-cut either, is it? The flexibility in the law can sometimes backfire.
It can. And the collection really stresses the urgent need for clarity around deprivation of liberty. What actually is it? If we can't agree on that, the legal protection against it starts to look a bit weak.
Then there are complex clinical ideas like insight, particularly in things like schizophrenia or bipolar disorder. How aware is someone of their illness, and how does that affect treatment decisions?
It's a huge factor. Research highlighted, like Raffard et al.'s work, suggests many people with schizophrenia may not believe they have an illness, this lack of insight.
And that can be quite stable.
Apparently so. The collection mentions the case of NI. The review board noted her limited insight into schizophrenia, even though she acknowledged an eating disorder. It just shows how nuanced these judgments about capacity are.
And what about that term noncompliance?
Oh.
The collection warns against taking that at face value.
Definitely. It's a loaded term. Noncompliance might not just be about the mental state. It could be about disagreeing with the doctor, fear of side effects, life stress, just not understanding the plan. Lots of reasons.
That sounds like there's a real risk of misinterpreting behavior if you don't look deeper. The collection also flags potentially problematic labels used in clinical files, like promiscuous or violent.
Yeah, using promiscuous, especially for women, risks pathologizing choices and reflects societal biases, not necessarily clinical facts. Some laws now explicitly say you can't use that alone as grounds for mental illness designation.
Thank goodness.
And violent, that label needs extreme care. Violence has many causes, not just mental illness. Simply repeating old notes without context can be really prejudicial.
And finally, impairment of judgment. The risk there seems to be that it becomes a critique of someone's lifestyle choices rather than an actual assessment of their reasoning ability.
That's the danger. The collection mentions the case of AC, where schizophrenia and cannabis use intersected. Is the judgment impaired by the illness, or is it a choice the clinician disagrees with? It's tough.
So it seems there's often a disconnect between the formal legal criteria for involuntary status and the range of factors clinicians and tribunals actually consider.
That's a really critical takeaway. The law on paper might not fully capture the messy reality of these decisions, which brings us neatly to the role of review processes and tribunals.
Right, the mechanisms designed to provide oversight and check these decisions. Speedy, regular review seems key. The collection mentions the European Court.
Yeah. The Winterwerp case established that timely judicial review is fundamental if someone's confined due to mental illness. But the collection notes, in practice like in Australia, average admission times can be short.
Meaning the review might not happen before the person is discharged.
Potentially, yeah, which could undermine that core right.
And what about those compliant voluntary patients? The HLV United Kingdom case seemed important there.
It was. It showed that even if someone isn't actively resisting detention, if there are doubts about their capacity to truly consent, they still need access to a review. It's about meaningful oversight, not just ticking boxes.
There seems to be a tension, though. The human rights approach says you must determine capacity, but some legal systems seem to treat clinical judgments of incapacity as almost final.
That's a key conflict. The CRPD is clear. A diagnosis doesn't automatically settle the capacity question, and people have a right to legal help when it's being decided. Some systems might defer too much to the initial clinical assessment without enough independent checks.
And getting these international principles into actual domestic law, that's another hurdle, isn't it? Sylvia Bell's point about courts being wary of telling the government what to do.
Yes, that judicial reluctance to step into areas seen as executive power, like how services are run or resource allocation, is a recurring theme. Courts might hesitate to overrule clinical decisions or mandate specific services, even with human rights concerns.
The Australian experience with guardianship laws is interesting here, too, moving towards tiered systems, letting people appoint their own enduring guardians.
Yeah, that shows an evolution towards respecting prior wishes. But even then, there's uncertainty about how far a guardian's power goes. Can they consent to detention or involuntary treatment under mental health law powers?
It's still a bit murky.
It seems so. The collection suggests guardianship might be used more in non-urgent cases, especially with good support networks, but the boundaries with mental health legislation aren't always sharp.
The collection also contrasts different models. The basic rights model maybe not fully addressing economic and social rights, and it looks at judicial review of treatment, like the Wilkinson case in England and Wales, focusing on therapeutic necessity.
Right. Wilkinson established a limited review right, especially if treatment borders on inhuman or degrading. The key was showing convincing evidence that the treatment was actually therapeutically needed.
But comparing judicial review to tribunals might be easier to access.
Potentially, yes. Less formal. But the collection raises concerns. Do they always offer enough procedural protection? Is medical evidence sometimes given too much weight without enough critical scrutiny?
Different places handle professional reviews differently, too. Ireland versus England and Wales, with questions about independence.
Exactly. How truly independent and effective are those reviews? It varies.
Now, shifting focus slightly, Canada, how has rights-based legalism played out there? The dangerousness criterion for committal sounds like it caused some issues.
It did. It was meant to be objective, but questions arose about how reliably it could actually predict danger. And separating capacity from committal in places like Ontario and the Yukon had this unintended consequence.
The warehousing issue.
Yeah, involuntary patients held, but not necessarily receiving active treatment because the capacity assessment was separate. A real problem.
And Canadian courts seem a bit reluctant to treat mental health law purely as civil law, especially regarding evidence before tribunals.
That's right. There's debate about whether evidence gathered, say, during a clinical assessment should be used in a tribunal hearing if it wasn't obtained with full legal cautions. And the nature of the tribunals themselves, sometimes inquisitorial, sometimes adversarial, adds another layer of complexity.
Trying to balance finding facts with protecting rights.
And the power of tribunals to compel testimony, they seem hesitant to use it sometimes, maybe due to self-incrimination concerns. Plus, appeals can take time, creating clinical dilemmas while waiting for a final decision.
It makes you wonder about the impact on the person going through it, their sense of dignity, of justice. The collection notes a need for more research on that lived experience.
Definitely. Qualitative research is needed there.
Okay, finally, let's talk about access to mental health services. The focus has really shifted, hasn't it? From just closing institutions to tackling barriers to getting community-based care.
Yes. The challenge now is, how do you uphold legal capacity, the right to refuse, but also ensure people get necessary care? It's incredibly difficult.
Human dignity is seen as foundational, but defining best interests is still tough, especially in mental health or fitness to plead situations.
Very tough. Does best interest mean purely health interests? That can lead to very broad definitions. And again, that judicial reluctance to interfere with government service provision comes up.
Even voluntary admission rules vary. The collection argues that not having clear pathways for voluntary access could itself be discriminatory.
It's a fair point. Access should be equitable. But implementing positive rights in mental health is hard. Vulnerability, stigma. There's a risk these rights become hollow if there's no real enforcement mechanism.
So suggestions like expanding tribunal powers or creating monitoring bodies, they're about adding teeth to those rights.
Potentially, yes. Strengthening procedural rights and maybe bolstering the claim to a positive right to healthcare itself.
And community treatment orders, CTOs, they get a lot of scrutiny for impacting liberty, security, privacy.
They do. The legal duty to accept treatment under a CTO, like in New Zealand, raises fundamental questions. Is compulsion ever truly compatible with rights?
There's that debate. Does compulsory community treatment maybe enhance someone's positive liberty, their ability to function, even if it reduces negative liberty, their freedom from interference?
That's the argument sometimes made. Concepts like relational autonomy, seeing autonomy as something built through relationships and support, or compassionate interference, offer different ways to think about it.
Families might support CTOs too, feeling it helps them care for their loved one.
Yes, that's often reported. But the collection is cautious about the evidence for CTO effectiveness. Many claimed benefits haven't been rigorously proven quantitatively.
And the principle of least drastic means is vital when justifying CTOs, right? Especially mentioned in the Canadian context.
Yeah, absolutely. Any rights limitation has to be proportionate and the least restrictive option available. And the powers within CTOs, treatment, monitoring, controlling residents, access, recall to hospital, all need intense human rights scrutiny.
Especially recall. The winter warp criteria apply there too.
They should, yes. Recall is a significant deprivation of liberty.
The collection also briefly touches on the U.S. context, how changing politics affected rights-based law there, and suggests international principles, like a right to health coverage, would be valuable additions.
Yeah, bringing in that broader right to health perspective.
And finally, it looks beyond the first world, Southern Africa, for example. Poverty, lack of services, traditional healers, a completely different reality.
And in some places, like Latvia mentioned, a real lack of functioning mental health laws or enforcement. It highlights stark global inequalities.
Wow. Okay, this has been, well, a genuine deep dive. It's so clear that balancing individual rights and freedoms with the need for care and protection, it's just an ongoing, really challenging process.
It absolutely is. And we've seen that clear shift, haven't we? From mainly negative rights towards embracing positive rights, pushed along by things like the CRPD.
But those gaps between the laws we write and the reality on the ground, they're still huge. Applying these sometimes quite abstract legal ideas to complex individual human situations is just incredibly hard.
It really forces you to think, doesn't it? This collection leaves us with a big question, I think. Considering everything, all the different views, the inherent difficulties, what does a truly rights-respecting and effective mental health system actually look like in practice?
Yeah, maybe even more fundamentally, what needs to change in society?
Yeah.
Our understanding, our resources to actually get there.
Exactly. It's certainly food for thought, a conversation that absolutely needs to continue.